A Florida man is behind bars after police say he confessed to punching a 1-year-old girl. His explanation, he claims he was just playing and admits he was high on marijuana at the time. That little girl did not survive, leaving behind her twin brother. Thanks for joining us. I'm Kennedi Walker, and I'll walk you through the details. You're watching Law and Crime. 1-year-old Ky'meria German was just learning to talk. Her baby babbles finally forming into real words. She loved to eat, she loved the color pink, but those early milestones would be her last. Ky'meria was a twin born alongside her brother, but now he's left to grow up without her. On the morning of June 23rd, just after 9 a.m., first responders rushed to a home in Tallahassee, Florida, after reports of an unresponsive child. That child was Ky'meria. Her mother was not home. She and her twin brother were being watched by the mother's cousin, but that cousin had already left for work, leaving the twins in the care of her boyfriend, Deric Young. Paramedics arrived and immediately began life-saving efforts. Young was at the scene when officers arrived. Ky'meria was rushed to the hospital, but she did not survive. Police say signs of abuse quickly became clear. According to a probable cause affidavit, an autopsy revealed Ky'meria had been hit multiple times in the head with a closed fist. Doctors say those blows caused her death. She also had a broken femur, an injury so severe doctors say it would have made it nearly impossible for her to crawl or move. But police say Deric Young later admitted to striking Ky'meria, even reenacting the brutal beating, allegedly using a closed fist to show just how he hit her. He allegedly described using both fists, hitting Ky'meria 2 to 3 times on each side of her head, face, and thigh. Young told investigators he was suffering from a lack of sleep and feeling stressed. When asked if he had lost his temper, Young insisted he had not, claiming he was simply playing with Ky'meria when he struck her. He also admitted to smoking marijuana shortly before the incident. Ky'meria's twin brother was in the room at the time but was not harmed. Young said that after hitting Ky'meria, he left the room, leaving her lying on the bed next to her brother. A short time later, he allegedly returned, checked her chest, and after hearing no heartbeat, rushed her to the living room and asked someone to call 911. Now, the 25-year-old is behind bars, charged with murder and aggravated child abuse. And here to break down this story with me is trial attorney Eric Schwartzreich. Eric, thank you so much for coming on today.
Thank you for having me today.
So let's just jump right in. From a legal lens, what makes this case particularly heartbreaking or difficult to navigate?
Well, anytime you're dealing with a child and an injury that's so violent or an accusation that's so violent, and a child that's punched, and here's a child that's left, the mother hires a babysitter, and the babysitter's boyfriend, is watching this child, and during this allegation of play or playtime, like the accused is saying, the child is harmed, the child is punched allegedly, and the child is hurt. It's very heartbreaking and a very difficult situation.
Absolutely. What factors determine whether a case like this is charged as first-degree murder or second-degree or anything else?
The difference between first-degree murder or second-degree murder or even manslaughter, which is possible, is intent. Now, there is felony murder in the state of Florida, and it is alleged in the probable cause affidavit that the felony here is aggravated child abuse. The claim of playing with the child, well, certainly seems like that could be some type of reckless conduct, whether it's manslaughter, involuntary, or voluntary, but aggravated child abuse, punching a child, striking a child in the face, striking a child in the leg, that's child abuse. Aggravated child abuse, and if you were engaged in the commission of a felony and someone were to die, that can still become first-degree murder, even though there is no intent to kill that child. Still makes it first-degree murder, and someone can still face the death penalty for an allegation like this in the state of Florida.
I want to thank Odoo for sponsoring this news package. Odoo is a powerful all-in-one business software that helps you manage everything from sales to accounting and, yes, inventory. Their inventory dashboard makes it easy to track receipts, delivery orders, POS orders, and see what's waiting, late, or back ordered at a glance. You can pay for receipts, automate vendor reminders, and schedule deliveries all in just a few clicks. Plus, you get full warehouse management, the ability to set picking strategies, and real-time stock visibility. And the best part, Odoo's inventory app syncs seamlessly with your sales and e-commerce apps, so everything stays connected. So right now you can get a free 15-day trial of Odoo's all-in-one business solution and see how it can make your life easier. Check it out at odoo.com/lcnewsinventory. And let's just talk a little bit more about intent, especially since he claims he was just, quote, playing. But even if you are playing, like, I guess just his reasoning of playing, it just isn't making sense. So you're saying that regardless of him saying that, oh, I may have been under the influence, or, oh, I was playing, that doesn't matter because of the injuries that were caused.
Certainly saying that you were smoking marijuana or you were under the influence of a substance can negate mens rea. You always have to have mens rea and intent to commit a crime. But in the state of Florida, voluntary or involuntary intoxication is not a defense. When the accused thinks perhaps maybe he's helping himself, and the statement says, I'm playing, to try and negate the intent when someone hears, oh, it's murder. There's a famous saying that defense lawyers like to say that a fish doesn't get caught if it keeps its mouth shut. You don't have to speak to the police. You don't have to give a statement. Here in this case, while the defendant or the accused might have thought that he was helping himself with that statement by saying, I was playing, trying to negate, as you say, the intent, what he is admitting to is reckless conduct or admitting to being engaged in child abuse and, different poisons. So maybe you don't get the first degree murder with the intent, but you can get the felony murder. You can be looking at, conduct that could be manslaughter and involuntary manslaughter in this case. But it seems like that based upon probable cause affidavit and the defendant's own admissions, his own statements, that the state of Florida has enough to go forward on a felony murder allegation, which the probable cause affidavit lists.
Right. And according to police, they say that the suspect did allegedly confess after. But what role does his alleged confession and reenactment play in strengthening the case? Because police, according to documents, say that they asked him, well, what exactly did you do? How were you playing? Can you walk us through it? And he allegedly reenacted how he hit this child.
It's everything for the prosecution in this case. Again, going back to that, you don't have to speak to the police. And this is a perfect example why a defendant, why an accused shouldn't have spoken to the police. Here, they had a child that had blunt force trauma. The autopsy would have shown that injuries. But the question is, in this case, is a who done it and a how done it. And so, what the defendant has done in this case is given an admission that he was the one that struck the blows, putting himself there, that he had contact with the child, and admitted to an act which he could get the death penalty for, or if not, certainly life in prison. His own admission in this case ties it all up in a nice little bow for the state and gives them evidence in this case. They would have perhaps had a tougher time. If this statement can't be suppressed, if it can't be thrown out because it wasn't a voluntary statement, this statement is very damning to the accused in this case.
Well, we'll talk about the potential for the death penalty in a moment, but just going on more just about his statement. If he initially denied everything but later confessed, how does that affect the credibility of his statement in court?
Well, it's always an issue, right? And the more you speak to the police and you say, I didn't do this, or you're silent, or you're not cooperating, well, your silence shouldn't be able to be used against you. Credibility as an accused, as a witness, is everything. So if you give multiple statements to law enforcement, first denying, saying it wasn't you, and then later say, well, it was me, but here's my reasoning, here's my rationale, which perhaps the defendant thought helps him, but it doesn't. That statement, conflicting statements, speaking to the police multiple times can be very detrimental to the credibility of a witness or a defendant. In this case, very damning.
Right. And in this case, we have the alleged confession plus the autopsy. But in cases without the confession, if you could just walk us through, how do police determine whether a child's injury is abuse or accidental, especially if no witnesses were there?
It's an excellent question, right? That's why the defendant's words are tying it up in a nice little package. If those words, if that statement comes in and they believe it, it's everything. Because without the statement, if you take the statement away, if you strip it, what law enforcement has is a child that, is dead. There's an autopsy. There's injuries that should not be there to the face or to the skull or to the legs or wherever they are in this case. And then the police had to put it together. Well, who was, who had custody of this child? Was it a mother? Was it a father? Was it another caretaker? Was it the babysitter that was hired? I mean, they would have had to put together pieces of a puzzle, because anytime in a criminal case, it's up to the state or the government, in this case, the state of Florida, to prove the allegation beyond a reasonable doubt. And the defense doesn't have to call witnesses, present, prove evidence, disprove anything. It's up to the government to put it together. So without a statement, there was perhaps a better defense that could have been utilized. Who did this? When did it happen? The defendant's own words in this case, you know, are the problem for the defense in this case.
And the defendant in this case, it was not a relative, but it was the mom's cousin's boyfriend. We're told that the mom left her twin infants in the care of her cousin, and then the cousin had to go to work, and the cousin left the babies with her boyfriend. Could she face any legal consequences?
She certainly could. And what law enforcement's going to do, and you've heard that the state attorney we've heard is still doing an investigation, they will get DCF involved, Department of Children and Family Services, to do an investigation to see if the twin brother or any or children are in danger, especially when there's another child there. And they can investigate the mom to see, well, what did you know about this individual? Why did you leave the child alone with him? From what I've read, that was not the caretaker that was hired. But if the mom left her child with someone that she shouldn't have, and used some conduct or perhaps really poor judgment, she could be culpable. She could be liable. She could be looking at child abuse or child neglect cases. And I do expect that in this case, I'm not saying it's there, but that is something that the state attorney's office and law enforcement will look into in a case like this.
Well, in this case, since it seemed like the mom was, and this is just from the outside looking in, it seems like the mom was doing the right thing by leaving her twins in the care of her cousin. But if the cousin left the babies with the cousin's boyfriend, I was wondering, could the cousin face any legal consequences? If it's like, hey, you were hired or you were asked, you agreed to watch these kids, but now you left these kids with someone that maybe the mom wouldn't have entrusted her children with. Could she face any consequences?
Certainly any of the caretakers will be looked into. And if a caretaker is entrusted, I mean, exactly what is a caretaker? Just by virtue, the nature of that word, leaves the child with someone else that they shouldn't have, or someone else that has questionable history, or someone else that is known to use drugs or smoke marijuana or has a prior history. I don't know if those things are here, but certainly any caretaker that entrusted this child with someone else will and could be looked at, and could, emphasis on the word, could face charges in a situation like this.
Now, the twin brother was present during the alleged beating. Could the presence of another child in the room strengthen the prosecution's argument of intent or recklessness?
And it's an interesting question. It's a double-edged sword. We know certainly the other child is in there, and it is recklessness. There were two kids, there were twins in there. But that child wasn't hurt. So how is that viewed, that one child in the mind of the caretaker was being more difficult, or being more fussy, if you will? How that plays into it, and how the state looks at that. Well, the other child wasn't hurt. What was the intent? Was the intent to hurt birth children? Is this someone that snapped in the heat of a moment, changing something, from a first degree murder down to a second degree murder? Or does it change it to a manslaughter? It's certainly a factor here, how that plays into this, and how the state or the detective is going to look at that fact with the other child, it, to be determined.
Right. And what we know is the kids are girl boy twins, and the child that died was a girl. The other twin was her brother. If, during the investigation we learned that maybe he allegedly targeted the girl child, could that be considered some type of hate crime? Because why hurt the girl twin and not the boy twin?
I don't know if I can consider it a hate crime. It's certainly an aggravator, and certainly something that's very interesting. Like, what is the reason? We've got two children, and then only one is hurt. I mean, the defendant seems to give a statement that he likes to play, and he was playing with them. And we have that interesting comment about what he would do to his own child, asked by the detective, and the detective says, "Would you do this to your own child and play and then strike the child?" To which the defendant says no. So why the other child wasn't harmed or hurt, it's certainly, it's relevant, but how it's handled in this case, as far as what the ultimate charges are, again, we'll see. It's certainly something that's interesting in this case.
How can the defense begin to argue this? I mean, could they argue that the fatal injury was unintentional, even if the blows were deliberate?
So the first thing the defense needs to do in a case like this is to see if they can suppress that statement, to see if the statement wasn't voluntary, wasn't knowing, wasn't intelligent, wasn't voluntary, that if it was done under a custodial situation, or if Miranda rights were not read correctly, and somehow this was a forced statement. That is a way to get that statement out. If the statement can come out, the defense is in a better position. If that statement comes in, another defense that could be used to try and attack, the statement himself. Sometimes just because a accused or defendant says something doesn't mean it's necessarily true. But the other option is to, a mitigation situation to try and show that this isn't first degree murder, that it's not felony murder, it's not aggravated child abuse, what occurred, that it was playing, or to try and knock this down to a manslaughter or a involuntary manslaughter, because with manslaughter, the maximum penalty in the state of Florida is up to 15 years under certain situations, up to 15 years Florida state prison. With first degree murder or felony murder, which is first degree murder, you could be looking at life and or death. So the other tactic might be to try and save your client's life, either from the death penalty or from coming out of Florida state prison in a pine box, with trying to see if you can get it down to a manslaughter where the exposure is 15 years, and try and resolve it that way. Certainly 15 years in Florida state prison for anyone is a long time, but it is, saving someone's life when someone's facing life and or death in prison, and you can try to take a case down to a resolution such as manslaughter when you have facts like this.
Yeah, that's a good point there. During the confession, police say that the suspect allegedly claimed that he was stressed, he was sleep deprived. Does claiming sleep deprivation or stress change anything legally?
So, recently in Florida, in one county, in a manslaughter case, the fact that someone was sleep deprived was used, and they drove a motor vehicle, was used to charge someone that they made a decision that they had not slept to get behind the wheel of a motor vehicle in which someone was killed, and the prosecution went forward on that. As far as it could be used for and against, because if someone's sleep deprived and they're around a child, that could also, if some another caretaker was aware of that, that could also play into other charges. As far as for the defendant, it could go to negate his mens rea as to intent, because intent is everything. But I don't think it changes things from a manslaughter in that sense, because that type of conduct, watching a child being sleep deprived, smoking marijuana, for whatever what anyone thinks about that, then being around the child, and his claim, the defendant's claim, as to how marijuana makes him feel to want to play, and I mean, playing and punching a child, they don't really go hand in hand, especially when this is an infant, not really a child. So it can go both ways, the sleep deprivation claim in this case.
Right. And what about arguing diminished capacity? Would a mental health evaluation be automatic in a case like this? Because like how we said, this isn't something that we hear about every day. A person claiming that they were playing, but they ended up allegedly punching a child to death. I mean, the first thing that comes to mind may be some mental health issues.
It certainly seems like there could be mental health issues. That's not a normal thing to say, that you were playing with a child, and could this be some type of sanity defense or diminished capacity, or you don't appreciate the consequences of your action type of defense. It could be. That is another avenue, and an avenue that I would expect the defense would go down in a case like this. Mental health experts to try and show the lack of mens rea, or perhaps as a mitigator as to the final outcome of this case, if there's a conviction in this case.
And let's talk more about the potential for the death penalty. How would that work? What would need to happen for the prosecution to argue that, for a jury to convict him on this?
Well, you got to look at, aggravators versus mitigators, whether or not aggravators outweigh the mitigators. It used to be, before the Stoneman Douglas case in Florida, that you need a unanimous jury to give the death penalty to someone. Now, out of the 12 jurors, you just need 8. If 8 of the 12 jurors decide that this case should be a death case because aggravators outweigh any mitigators such as, you know, was he under the influence of anything? Does he have prior criminal history? The accused's upbringing, the heinous and cruel nature of a crime like this for even with someone without prior criminal history, and the fact that the state of Florida could be seeking this under felony murder, the underlying felony being aggravated child abuse, and that it's an infant, certainly makes one think that if we have the death penalty, whatever someone's views are on the death penalty, that this is the type of case that might warrant this state attempting to get the death penalty. And now what they would need is just 8 of the 12 jurors voting in favor of the death penalty. If that were to happen in a case like this and go forward, then it's always up to the judge to look at the facts, and the judge could always override a recommendation for death. It's rare that happens, but judge would have that option.
And let's say the death penalty is not on the table. Would a plea deal ever be likely in a case like this, or is it just too high profile and too emotional to ever even consider one?
Another excellent question. Sometimes prosecutors will overcharge, or they'll bring death knowing that maybe someone will take a plea to life in case like to life, knowing that death is on the table. This is a high profile case. It involves an infant, a child. Prosecutors are also elected officials. The nature of this accusation, this type of charge, is probably the type of charge. Forget about the fact that this is a case, as I say, if you're going to have a death penalty, striking an infant like this multiple times is the type of case that would probably be difficult for a prosecutor not to bring death penalty unless there's some mitigating factors about the accused that we don't know about.
And one thing that I've noticed, just, covering a lot of cases like this, we've seen so many cases involving the deaths of young children in the hands of caregivers. Are prosecutors across the country pushing for tougher penalties in these kinds of cases?
Well, they are. And it's also, in the court of public opinion, and also when you've got, children being harmed, I mean, to send a message as well, too. Part of the death penalty, the theory behind it is, the deterrence, to deter. And I think a lot of prosecutors hope that if they, when these crimes happen and if they take a tougher stance, that we would see less of these unfortunate types of allegations or incidents or crimes.
Right. And I'm definitely hoping that we see less of them. Well, this is a story that we will be following very closely. Eric, thank you so much for coming on today.
Thank you for having me. It's my pleasure.
Deric Young was booked into the Leon County Jail, where he is currently being held without bond. Ky'meria's family has made a GoFundMe. They are raising funds for the infant's burial. For Law and Crime, I'm Kennedi Walker.